the name of their judge. Well, don't you think that's important? Do you think all judges are the same? They're not. Judges are human, which means that they're all different in their approach to a case. Basic background on a judge is very easy to get. All you have to do is go to Google, type in the Unified Court System. There you will see a little photo of your judge and a bio, including the schools she attended and her employment history. Lawyers and community organizers who you will talk to will have even more information about the judge.
Her sweetie, Kirk Robin, was inhaling a bottle of hooch at a table, and a hoofer by the name of Buck Wing was getting ready to shake his tootsies.
Kindly speak English and drop the vernacular.
Vernacular? That's a doiby.
Drop the vernacular.
As I said a while ago, most non-payment cases are settled. The settlement agreement is known as a stipulation, or just STIP. The way it works is this. A landlord's attorney will find you in the courtroom and ask to speak about your case in the hallway. Remember that the landlord's attorney is not on your side, and so the only thing he wants to know is when you're going to pay the rent. In fact, the most common question that they'll ask at first when they meet you is, so when are you going to pay the rent? In a non-payment case, there are dozens of different defenses at trial. But let's not talk about trial for a minute. Let's talk about the settlement. Settlement should happen, in general, for all cases where tenants want one of two things, or both of these things. If the tenants want time, or tenants want repairs. If you need repairs, you say that you are ready to pay the rent when the landlord agrees to do the repairs. You provide a list of the repairs. You provide the times that you have told the landlord about this problem previously. And you provide the dates that the landlord can come in to make the repairs. If you gave the landlord notice of major repairs and he did not respond for a long period of time, you will want an abatement of rent. Rent abatement means that the landlord did not provide all the services which are mentioned in the lease, and therefore you are not obligated to pay all of the rent. If you paid for a quarter pounder with cheese and you received a quarter pounder with no cheese, then you would be entitled to a partial refund, correct? So if you rented an apartment and the landlord failed to provide you with a working bathroom, then similarly you would be entitled to a partial refund. In order to get an abatement, you have to establish the dates that you notified the landlord of the repair. And of course, it's best if you notify the landlord in writing. So in the stipulation of settlement in your case, you want the landlord's attorney to itemize the items to be repaired, the access dates, and if you can get it, the amount of rent abatement. That takes care of repairs. Now let's talk about the issue of time. First of all, I cannot advise you to sign a stipulation where you agree to a timetable for paying the rent unless you have a confirmed source for that rent arrears. If you just blindly sign a stipulation stating that you promise to pay the rent in 2 months, then you're asking for trouble. If you intend to get the rent from a charity, from Human Resources, or from a relative, well, you had to have an approval for that money before you sign the stip. If you don't have an approval, get a postponement so that you can get that approval on your next court date, and then try as hard as you can before that next court date to get that approval. Once you get the approval, then you'll know how much time it will take to get the money. Communicate that to the landlord's attorney and make sure the stipulation gives you the amount of time you need. If the landlord's attorney is not cooperative, go to the courtroom and request a conference in front of the court attorney. If the landlord's attorney is nasty to you, request a conference in front of the court attorney. If the landlord's attorney does not agree to a postponement, request an application in front of the judge. Okay, so now you have come to an agreement with the landlord's attorney on the time, the repairs, and any other issues. So now the landlord's attorney will proceed to writing out the stipulation. In the stipulation, there is bound to be a lot of language that you will not understand, but generally you will get to review the stipulation with both the court attorney and the judge before you're asked to sign it. As a result, I won't belabor the finer points of the terminology that you will find in the stip. Nevertheless, I do want you to get to understand one very important, if technical, concern that you should have. I want you to have a basic understanding of a law called RPAPL 747. If a judgment is provided in the stipulation, then you have to watch out for RPAPL 747. This law can deprive a court of the discretion to give you more time if in fact something delays you from paying the rent. This is dangerous. The way the tenants regularly handle this is to make sure that the stipulation provides that RPAPL 747 is waived, or that the stipulation provides one order to show cause for good cause shown. Okay, life doesn't go as planned, and so it's very common that the tenant does not have the rent arrears by the deadline that is provided in the stipulation. So what do? You go back to court and file an order to show cause for more time. The objective is to get the judge to sign an order to show cause the same day that you filed it. Will he sign it? It depends. A judge is likely to sign an order to show cause if you can attach an approval from an agency who will pay rent arrears. If the deadline is passed but you now have all the money, you can attach a copy of the money orders. A judge will probably sign an order to show cause if the failure to pay is completely due to the delays of the local welfare agency. A judge is less likely to sign an order to show cause if there have been several orders to show cause on the case. Once the order to show cause is signed, you get another court date in which you meet the landlord's attorney once more to get either an order or a stipulation to provide for more time. If your case drags on, another law comes into effect that you should know of called the rent deposit law. 30 days after the first court appearance, or upon the tenant's second request for adjournment, whichever is first, the landlord can apply to have your rent deposited with the court. When this rent deposit law was enacted, it was expected to revolutionize the landlord's ability to speed tenants to eviction. Well, it hasn't turned out to be quite as easy as they thought. Landlords find the procedure of depositing the rent with the court and the procedure of getting the rent deposit released to be very inconvenient. So, instead, the courts may order the tenant to pay the ongoing monthly rent as a condition to getting more time to pay the rent arrears. That is, unless the tenant's on welfare, in which case depositing the rent is seldom an option. Most housing court advocates will say that I presented too little information in this video, while a lot of novices will feel overwhelmed and feel that I presented too much. Whatever the case may be, I hope that this video will serve as a tool that you could use with your other resources in order to effectively fight your housing court case. See you in court.